Hello, everyone. Welcome to Landlord Self-Help Center's Landlord Education Series. My name is Alda, and I am one of the community legal workers at the Landlord Self-Help Center. This presentation is being recorded, so please click on the pop-up to acknowledge and accept. We also ask that you please keep yourself on mute. Landlord Self-Help Center is a specialty community legal clinic funded by Legal Aid Ontario. We provide summary legal advice, general information, and referrals to low-income, small landlords across Ontario. We provide public legal education initiatives to help landlords learn and understand their rights and responsibilities under the law. Our website contains information, resources, and learning tools addressing topics related to residential tenancies. Our staff, consisting of 5 community legal workers, help thousands of small landlords every year. This is the 6th presentation of our Landlord Education Series. Previous presentations covered rent increases, N12 and N13 termination process, LTB applications post-tenancy, standard form of lease, and conflict of resolution and mediation. These presentations have all been recorded and are all posted on our website where you can view them at any time. The presentation today is meant to help small landlords understand the role of the rental housing enforcement units of the Ministry of Municipal Affairs and Housing. They will be providing information on the role of the rental housing enforcement unit and how they can help in dealing with tenants or landlords not following the rules. They will also provide an overview of the more common offenses and penalties, including the recent changes pursuant to Bill 184. This presentation offers general information only, not legal advice. There will be a question period at the end of the presentation. We will be answering the questions that were sent to us by email, as well as live questions through the chat function. My colleague and fellow community legal worker at Landlord Self-Help Center, Silvana, will be monitoring the chat and assisting with the question period. Please keep your questions related to today's presentation topic. We will now pass it over to Suzette Carr, Danai Elam-Saget, and Dave Gregg from the Rental Housing Enforcement Unit.
All right, thank you, Alda. I'll just do a brief introduction before we hand it over to Suzette, Danate, and Dave. My name is Jim Toretto, and I'm the manager of the Rental Housing Enforcement Unit. And just like to thank Landlord Self-Help for the invite today. It's a pleasure to be here. And we've had many years of experience in working with Susan Vankevich and company there at Landlord Self-Help, and we appreciate the opportunity to spread information about the sort of work that our unit does and how we can assist landlords and tenants in Ontario with enforcement issues. So as you mentioned, we're going to be going over what we do in the unit, and we have 3 people within our units. Suzette, who's a senior program advisor within RHEU. We have Danai Elam-Saget, who is a compliance officer who answers calls and takes complaints from landlords and tenants every day, as well as Dave Gregg, who is coordinator of investigation within the Rental Housing Enforcement Unit, and he has years of experience in terms of investigations and prosecutions with RHEU. So glad to have this team available today to walk you through the slide deck. So at this point, I'm going to hand it over to Suzette Carr.
Thank you, Jim, and welcome everyone to this presentation today. So again, we are from the Rental Housing Enforcement Unit, which is a unit within the Ministry of Municipal Affairs and Housing. And a bit about us. The Rental Housing Enforcement Unit is responsible for enforcing over 50 offences under the Residential Tenancies Act. Our enforcement mandate serves to protect the rights of tenants and landlords through direct intervention when complaints are received through the unit's call center. We focus on a rapid resolution of potential offenses, Urgent complaints may be resolved on the same day. This contrasts with the application and hearing processes at the Landlord and Tenant Board, which I'm sure you're all familiar with. We are part of the Ministry of Municipal Affairs and Housing, and we are separate from the Landlord and Tenant Board, which is part of Tribunals Ontario. Offenses under the Residential Tenancies Act are listed in sections 233, 234, and 235 of the Act. Some common landlord offenses include landlords withholding a vital service, such as shutting off the utilities, which are described as hot and cold water, electricity, gas, and heat, changing the locks and not providing a key to the tenant, taking back possession of the rental unit without following the rules under the Act, entering the rental unit without providing proper notice for a reason that is not allowed under the Act or at a time that is not allowed under the Act, refusing to provide a receipt to a tenant or former tenant upon request, collecting illegal deposits from tenants, for example, damage deposits. Some common tenant offenses include changing the locks without providing the landlord with a key, denying a landlord entry after a lawful notice of entry was provided.
That one must have done that this morning then, right?
Correct.
Offenses that result in charges require the Crown to provide the offense, to prove, that the offense occurred beyond a reasonable doubt at the Ontario Court of Justice. If convicted,
Important.
the maximum fines under the Residential Tenancies Act are $50,000 for individual and $250,000
You are
for
so lucky
corporation.
I am here.
Sorry, can you guys put it on mute, please? Thank you.
And this diagram just illustrates the enforcement process, the main stage of the enforcement process within it. We use a progressive enforcement approach comprised of 4 main stages. The call center intake, we roughly get about 20,000 calls per year into our call center. Intervention cases, those are then sent on or forwarded on to the investigation section when compliance is not achieved at the intervention stages. And from the investigation stages, those that meet the criteria then proceed to the prosecution stage. I'm going to turn things over to Denise to discuss the enforcement process.
Thank you, Suzette. So the first stage in the enforcement process is intake, where the public can call the Rental Housing Enforcement Unit's call center and speak to a compliance and customer service officer, such as myself, who will be answering questions, providing general information, referring to other agencies when appropriate, and then opening a case after assessing and determining whether or not an offense has been committed under the Residential and Tenancies Act or allegedly committed under the Residential and Tenancies Act. Once a case has been opened, we would move on to the second stage of the process, which is the intervention. The compliance and customer service officer in this stage will be contacting the alleged offender to educate them on the law and seek voluntary compliance. Typically, this involves calling the person over the phone and sending a letter by mail and/or email. The letter would outline the law, the nature of the complaint, and the potential penalties if compliance is not achieved. At the end of the process, if compliance is achieved at this stage, the case will be closed. However, if it's not achieved, the case will be moving on to the third stage of the process, which is in the investigation process. Typically, it could take a day to several weeks, depending on the circumstances. Suzette, if you move it to next, thank you. Once a case is forwarded on to the third stage of the process, the investigator assigned would then gather the evidence and determine if there is ground to lay charges against the alleged offender. If there are grounds to proceed, the investigator would then seek the Crown Counsel's approval to proceed for prosecution. If the Crown Counsel gives the approval, the case will then be going to the last stage of the process, prosecution. In this stage, the investigator would then initiate the laying of charges. The case will be proceeding, the court proceeding will be occurring in the Ontario Court of Justice. Both landlords and tenant can be subject to prosecution under the Residential Tenancies Act. And as previously mentioned by Suzette, the maximum fine for individuals could be up to $50,000, and for corporations, it could be $250,000. The typical enforcement timeline, again, these are all dependent on the circumstances, but the investigation stage is a day to a month from open to when it's either closed or forwarded on to investigation. For investigation is a month to 4 months. Again, depending on the circumstances, it could either get closed or recommended for prosecution. And then the last process will be prosecution stage, and that could take up to a year. The Rental Housing Enforcement Unit does not, however, send enforcement agents to enforce the Residential Tenancies Act or conduct inspections. We do not evict tenants or enforce eviction orders. That would be the Landlord and Tenant Board, and then the sheriffs. We also don't open cases for non-payment of rent. We are seeking voluntary compliance from the alleged offenders, so we don't force individuals to do things that we're asking them. We provide the education and the tools to do things legally. Is a few of the things that we don't do, but the rest of them are also stated in the slide, such as we do not provide legal advice. We don't interfere in matters that are not within our jurisdiction, and we don't automatically lay charges upon just hearing one side of the story. Some of the common offenses that could be committed by tenants are denial of entry by a tenant after a landlord has served notice to enter the property. The first thing to note is the notice of entry should have been served to the tenant at least 24 hours prior to the entry. It should specify the date and the time of entry. The time of entry should be specific if possible. If not, specify the reasonable window of time and indicate the reason for the entry. In these type of cases, once a case has been opened, a compliance officer, customer service and compliance officer will be reaching out to the tenant to educate about the law, I apologize, and seek voluntary compliance so the tenant can allow entry for the landlord and their landlord's agents. A landlord could also choose to serve an N5 notice and proceed with the Landlord and Tenant Board. Serving the N5 notice does not prevent a landlord from filing a complaint with our office. The other offense is tenant changing the lock without the landlord's consent and not providing a copy of the key to the landlord. In this type of circumstances, the compliance and customer service officer will be asking the tenant to provide a copy of the key to the landlord or reinstalling the original lock. The landlord in this type of scenario has two other options as well. One of them is to file the L8 application with the Landlord and Tenant Board, and also serving a notice of entry to change the locks and provide a copy to the tenant. Now I'll pass it on to Dave to cover the rest of the offenses.
Afternoon, everybody. So as said, my name is Dave Greck and I'm the investigation coordinator. I'm going to take you through the rest of the slide deck. So as you can see, one of the offenses that's most commonly committed by the tenant is furnishing false or misleading information with the Landlord and Tenant Board. It's important to know that with this particular offense, the false and misleading information has to be included in a document filed with the Landlord and Tenant Board in support of an application. We do not act on oral testimony that may be given during the board hearing. The most common examples of false information being filed by tenants are fraudulent rent receipts, where some tenants have been known to forge the landlord's signatures, or they have been known to file falsified lease agreements and also falsified bank documents, which they then file with the board in support of an application claiming to have paid arrears owed. If during any of these, during the application process, you do feel that the tenant may have filed false and misleading information with the board, you should contact us immediately. These particular complaints go straight to an investigation. We do not try the intervention process. So some common landlord offenses that we deal with. One of the most common is withholding vital services. So it is an offense to withhold or interfere with the reasonable supply of a vital service, care service, or food, or interfere with the supply, and that's in contravention of Section 21. Vital services under the legislation include hot and or cold water, fuel, electricity, gas, and heat. When it comes to heat, rental units must be maintained at 20 degrees Celsius from September 1 to June 15th. As I said earlier, this is one of the most common complaints that we receive. Landlords should never, ever instruct a utility provider to disconnect the vital service if the property is tenanted. If the tenant is responsible for paying the utility, but is not paying the landlord does have the option to file the application at the LTB for the utility arrears. Altering locks. This is probably the second most common complaint that we receive against landlords. So as it says there, it's an offense for a landlord to alter or cause to be altered the locking system on a door giving entry to a rental unit or a residential complex in a manner that contravenes Section 24. Landlords cannot change a lock to a rental unit without following the rules with respect to ending a tenancy. Only the court enforcement officer, better known as the sheriff, can evict a tenant pursuant to an order from the board. And once an eviction order has been obtained, the landlord does have to contact the sheriff to enforce that order. Many scenarios occur regarding where a tenancy exists, whether the property is covered under the act or whether the unit has been abandoned. One thing that we suggest, landlords should always exercise caution, and it's always best to check information sources, including the landlord and tenant board, or seeking legal advice when necessary in those types of situations. Rent receipts. This is a quite common complaint that we receive around tax time. So under Section 109 of the Act, a landlord has to provide free of charge to a tenant or a former tenant on request a receipt to confirm the payment of any rent, rent deposit, arrears of rent, or any other amount paid to the landlord. Failing to provide the receipt is an offense under the Act. The receipt, under the legislation, it does specify the information that has to be contained in a receipt, and they are as follows: the address of the rental unit, the name of the tenants to whom the receipt applies, the amount and date for each payment received, the landlord's name must appear on the receipt, and the signature of the landlord or their authorized agent. All of this information must be contained in a rent receipt in order for it to be valid. Illegal charges. It is illegal for a landlord to charge or collect amounts from a tenant, a prospective tenant, former tenant, subtenant, potential subtenant, in contravention of Section 134. Illegal charges are a fee, premium, commission, bonus, penalty, key deposit, or other like amount of money, whether or not the money is refundable. So basically, landlords are not permitted to charge damage deposits or end of tenancy cleaning fees. If you feel that the tenant has caused damage to your rental unit, you can pursue the damages through the landlord and tenant board. Also, landlords may charge a refundable key deposit. However, the amount cannot be greater than the expected direct replacement costs. And one thing to add is when the key is returned to the landlord, the key deposit must be repaid to the tenant. Landlord's own use. I saw that you already had a session on the Form N12s, but as I'm sure you all know, that you can serve a notice of terminated tenancy if the landlord in good faith requires possession of the rental unit for at least 1 year for the landlord, their spouse, the child or the parent of the landlord or the landlord's spouse, or a person who provides care services to the landlord, their spouse, children, or parents. Now, when an N12 is served to a tenant, there is the potential for two offenses to take place. The first one is the landlord, one serving an N12 on the tenant, as when the tenant vacates the unit pursuant to N12, the landlord is legally required to pay the tenant 1 month's rent, or they have to provide the tenant another rental unit that is acceptable to that tenant. And again, the payment has to be made once the tenant vacates. Failing to pay this amount is an offense under the Act. Now, the other time that we can pursue a matter for an N12 is a bad faith notice. So landlords are presumed to have given the notice in bad faith if they've done any of the following within 1 year after the tenant vacates. So advertise the rental unit for rent, enter into a tenancy agreement in respect of the unit with somebody other than the former tenant, advertises the rental unit for sale, or the building for sale, demolishes the rental unit of the building, or takes steps to convert the rental unit or building to use other than residential premises. Again, the notice in bad faith is another offense under the Act. So in addition to facing potential charges under the Act, the tenant could file a T5 application, and there are various remedies that the board can put in place, such as paying the tenant's rent for up to 1 year. They could order the landlord to pay the tenant's reasonable out-of-pocket moving or storage expensive, provide them a rent abatement. They can also issue an administrative fine. You can find all of this on the LTB website. Termination for renovation or repair, which is the Form N13. So the Residential Tenancy Act, it does allow landlords to serve a notice of termination if the landlord intends to demolish the unit or convert it to a purpose other than residential purposes. Also to do repairs or renovations to the unit that are so extensive that their building permit is required and the landlord needs vacant possession of the rental unit. Again, there are two possible offenses when it comes to serving of the N13. The first one is when the landlord recovers possession of the unit and does not compensate the tenant as outlined under the Act. The amount of compensation that has to be paid depends on the number of units. So if the residential complex contains 5 rental units, or at least 5 rental units, compensation is 3 months. Or, sorry, you went ahead. Can you go back, please? 3 months of rent or another rental unit acceptable to the tenant. If there's less than 5 units in the residential complex, then only 1 month rent has to be paid, or another unit acceptable to the tenant offered. Next, please. Now, if a landlord, again, when the N13 is issued for renovations, the tenant does have the right of first refusal. So upon receiving that notice, if the tenant has given the landlord notice in writing before they vacate that they want to move back into the unit after the repairs are completed, the landlord, and they have the right to do that. They also have to provide their landlord with their new address. If a tenant was not given the right of first refusal to reoccupy the unit, then the landlord is maybe committing an offense under the Act in this situation. So a tenant does have the right of first refusal, and they must be given access, return to the unit in those situations. So some overall tips. Always take the time to document important interactions with your tenants. Because the reason we ask that you do that is because we may ask you for that documentation if we open a case. Always use the standard lease form. It's now the law. Breakdowns in understanding are common when there is no lease agreement, so it's always best to have that lease agreement. Always keep open lines of communications with your tenants. Be aware of the RTA rules and offenses. If you're not aware of the rules, take time to check. Ensure your actions are lawful and always follow proper procedures. Do not, and this is to me is the most important thing, do not take matters into your own hands. For instance, like if your tenant is in arrears of rent, there are remedies available to you to initiate the eviction through the board. What we are finding is that when a tenant falls into arrears of rent, as opposed to taking the legal requirements, following the legal requirements, what landlords are doing are changing the locks, or they're shutting off the vital services. Those are offenses under the Act. So it's always best to follow the requirements. One other thing that I do want to add is when you do give your tenant a document bearing your signature, always, always, always keep a copy of that document. It's very important to keep those because with today's technology, it's very easy for tenants to take a landlord's signature from a document and put it on another document, which is what we're finding when it comes to false information cases. That's everything I have to say for now. So I believe we're opening up. There's our contact information, our toll-free number, as well as the local number. And there's also the address.
Yes, thank you so much for your attention during this presentation. We will now address your questions. We will be answering questions previously received as well as live questions shared in the chat function. If you're not able to ask a question today, please call our office during our regular business hours, and we will be happy to assist you. So we will now take your question.
And Aldo, if I could just add just quickly before we get into them, and I think it was covered off the top, but we deal with so many different scenarios and situations within rent housing enforcement. So we try to answer the questions the best we can from a general sense. But typically what we find is that we really have to dig into a lot of the facts and understand the complete situation. So, we'll do our best to answer these questions in a general fashion.
Okay, yes.
Okay. So now we will start with the questions that were sent to us by email. Okay, so the first question is, I have rented a house to a tenant and I'm wondering how often I can enter the property to do a maintenance inspection. I have been inspecting the property on a monthly basis, but the tenant is now complaining that it's too frequent. Can the tenant file a claim with the RHEU for harassment? Can anybody answer that?
Sure, I'll answer it. This is Denite.
Hi, Denny.
And to simplify it, there isn't really a number in the Residential and Tenancies Act that says this is the number of inspections that you can do a week, a month, a year. It's just that a landlord should keep in mind not to do it too excessively to the point that it's interfering with the tenant's enjoyment of the rental unit. And if the tenant feels that it's now too excessive, they are able to file a complaint with our office.
Okay, thank you. Okay, so the next question is, am I allowed to enter the common areas of a rental unit without 24 hours written notice? Would this be considered an offense if I do? Can anybody answer this?
I'll take that one. My assumption is that you're talking about, the question relates to a rooming house. Our position is that as long as the landlord is only entering the common areas, they do not have to serve a written notice of entry. However, again, tenants do have the reasonable expectation of privacy. So landlords cannot just constantly go in and out of the common areas daily or weekly, because again, that could be construed as interfering with a tenant's reasonable enjoyment. Also, when they are in the property, in the common areas, the landlord does have to conduct themselves in a proper fashion.
Okay, thank you. Okay, the next question. I would like to do some landscaping work on my rental property. The tenant is insisting I provide them with a 24-hour written notice. Is it an offense if I do landscaping without providing them the notice?
This is Denite again, and I will answer that question. Well, there's a lot of questions that will be coming from that particular question, but to just state it in a general sense, if a tenant has exclusive use to the rental property, the landlord could be required to give a 24-hour notice prior to being there.
Okay, thank you, Danette. So the next question, my tenant who just moved in agreed to transfer utilities to his name, but didn't. It states in our rental agreement that he is responsible for all the utilities. Will I be committing an offense if I disconnect the utilities?
I can take this one.
Okay.
It depends. So firstly, if it's the tenant's obligation to pay for the utilities and they do not change the name on the account to theirs, and it gets disconnected just because they are not paying the bill, then no, it's not an offense. However, the end of that question says, is it an offense if I disconnect the utilities? The legislation says withholds or interferes with the reasonable supply of a vital service. If a landlord takes any sort of action which leads to that vital service being disconnected, then that can be viewed as interfering with the vital service. Landlords in that situation just let the process go. If it's the tenant not paying the bill, it then gets disconnected, then no, the landlord is not committing an offense under the Act.
The next question, the tenant refuses to allow showing to prospective buyers, even though a proper 24-hour notice is given. What can I do in that situation?
Okay, I'll take that question. The landlord can file a complaint with our office for the denial of entry, and I just want to make sure that the denial is actually happening the day of at the time specified in the notice of entry. So if a tenant gets the 24 hours, sends a text message to the landlord saying, I prefer that you don't come, that's not necessarily a denial. The denial should be on the date and the time that the landlord scheduled, goes to the property and see if the tenant prevents entry at the door. The landlord would also have the ability to serve the tenant an N5 notice in addition to filing a complaint with our office. I would like to point out, if it's a realtor that's going to the property with the prospective buyers, the real estate agent should ensure to have a written consent from or written authorization from the landlord.
First question, did you say that the RHEU prosecutes cases in divisional court under RTA? Have you recently prosecuted cases in divisional court?
I can take this one. Our matters are dealt with in provincial offences court, same area that you deal with highway traffic offenses and things like that. Things have been, with COVID, things have obviously been a little slower because there was a length of time where the courts were shut down. We are finally doing some trials via Zoom as well. And yes, over the last little while, we have secured a few convictions.
Can a landlord who just sold the unit and transferred to the purchaser still pretend to be the landlord and issue notice of entries and try to enter the unit?
Do you want me to take that one tonight?
Yes, please.
Yeah, no, I mean, if the selling individual is no longer the landlord, then they do not have a right to enter that rental unit. The legislation quite specifically says a landlord may enter a rental unit. So if they are not the landlord, then they're not allowed to enter.
Must the landlord reissue rent receipts if requested by the tenant, even if the landlord had previously given rent receipts?
Would you like me to answer that, Dave?
Sure.
That would be a no. So if the landlord has already issued a valid rent receipt, the landlord is not obligated to reissue a new one if a tenant lost it or misplaced it.
Could a landlord repair the place and keep the place in vacant for 1 year before renting out or selling? I guess this would be after an N12 is served.
So an N12 is served. Sorry, can you say the question again?
Could a landlord repair the place and keep the place vacant for a year before renting out or selling?
That's actually an interesting, question. I've never come across that before.
Well, I read online if it's bad faith, then that's what it'd be considered as. If you can prove in that year that it wasn't renos or anything like that, you have to prove a lot. That's what I was reading a lot online.
Yeah, I mean, that does make sense as to what Andrea just said.
Right.
would-
Well, if
it
a
would-
landlord serves an N12 to move in, then they have to move in.
Right, and they should be taking occupancy of that unit.
Right. Or else it would be considered bad faith.
Yes. Yeah, I'd agree with that.
Tenant first right to refusal. Does the landlord have to offer the renovated unit at the same rent previously paid?
Yes. Yes, the tenant moves in on with the same terms and conditions.
Okay, thank you. In the case of a tenant repeatedly denying access for inspections, claiming a family member testing positive for COVID, what does the RHEU typically advise?
Yeah, this is, I'll just start off, and Dave and Danette, you can chime in as well. This has been obviously a very challenging type of situation over the past, couple of years now. So, in the past, we have been, advising landlords and tenants to work together the best that they can in terms of working out these sort of situations that are related to COVID. In terms of tenants that might have a real issue with respect to a family member who may have COVID, I think we're asking landlords tenants to work together the best they can, and if there's any way to defer the entry until such time as if it's safer, that should be looked at. Obviously, with COVID restrictions being lifted now, we're hoping that these type of situations will ease, but we have approached these with a lot of caution in the past.
Okay, thank you.
Remember, we only deal with offenses under the Act. So if a landlord or a tenant are alleged of committing an offense under the Act, that's when we can get involved. If they're not complying with bylaws, then it's not necessarily an offense under our Act.
Oh, sorry, I was just going to mention, if it's a bylaw issue with a municipality, that would be obviously a municipal area, and you'd be calling your municipality about that. We wouldn't enforce bylaws with an RHEU.
Can your tenant block you from contacting them?
Can a tenant block? You mean
contacting them?
In response to a complaint that we receive, I'm assuming? When we do the intervention process, the compliance officers will always do their best to contact the alleged offender. They try to do it within 24 hours. Sometimes it may take 48 hours. If we don't contact them via the phone, then an intervention letter will be sent to the alleged offender, and the intervention letter outlines the details of the complaint received, what the legislation says, and then what could happen if they don't comply with the Act. So an intervention letter will always be sent out. If we at no time correspond with the alleged offender, or in this case, the tenant, and the tenant still does not comply, then that would get referred to an investigator.
Okay, so that will be it for the question period. You can use these resources to obtain more information on today's topic, as well as the laws, rules, and regulations. Thank you to our partners and fellow presenters from the Rental Housing Enforcement Unit. On behalf of the Landlord Self-Help Center and the Rental Housing Enforcement Unit, thank you so much for attending this presentation. We would like to remind you to please fill out our participation survey based on this presentation, and we look forward to seeing you in our upcoming presentations. Bye, everyone.